Sir, in page number A7, I had mentioned the summary of the case. Sir, Home Tolerant Science Films Limited (HTCF), a reputed production house in Zambia, released a film titled The Parallel Story in April 2023. The film was based on real-life inspired events about human trafficking, mentioning that over 22,000 boys were trafficked between 2017 and 2022. The teaser and trailer also referred to the involvement of the Bakavi community, a minority group, which led to public outcry and criticism. Despite controversy, the film was cleared by the Central Board of Film Certification (CBFC) and later by the Supreme Court of Zambia, which ordered the production house to clarify that the numbers mentioned were fictional due to lack of official data. HTCF compiled and released the movie after necessary modifications. Soon after its release, protest and communal violence broke out in the state of West Bengal, particularly in Behra, citing disturbance to public order and spread of communal hatred. The state government banned the film under Section 6(1) of the West Bengal Cinema Regulation Act 1954. Sir, the first point which I had mentioned here is CBFC certification confirms legal validity of the film. The Central Board of Film Certificate (CBFC), the statutory body under the Cinematic Act 1952, granted certification to the film. Once certified, the film is deemed suitable for public exhibition and cannot be arbitrarily restrained. Sir, in the case of S. Ranjaran versus P. Jagivaran Ram, 1989, if the film is unobjectionable and cannot constitutionally be restricted under Article 19(2), freedom of expression must prevail. The court held that mere anticipation of violence is not a valid ground to restrict freedom of expression once a film is cleared by the CBFC. Sir, the second is judicial clearance further validates its release. The Supreme Court of Zambia examined the controversy around the film and permitted its release with minor modifications. Sir, judicial scrutiny validates its legal correctness and overrides any future executive action based on vague grounds. Sir, in the case of Prakash Jha Productions versus the Union of India 2011, the court stated that once a film is cleared by CBFC and the judiciary, the state cannot impose further restrictions simply due to public sentiment or political concerns. Such cinematic expression is a form of constitutionally protected speech. Films are a legitimate medium of communication protected under Article 19(1)(a), even if content is controversial or uncomfortable. It is protected unless it directly incites violence or violates the conditions of Article 19(2). Sir, I had also mentioned one case law which is A.K. Abbas versus Union of India 1970. The court held that films are a form of artistic expression and protected under free speech. Sir, the state cannot override judicial orders. Sir, the Apex Court already ruled that the film must be considered fictional and allowed its release. The state's action violates the principle of federalism and separation of powers. Sir, in the case of Creative Private Limited versus State of West Bengal 2019, which is a recent case, the Supreme Court held that once a film is certified by the CBFC, state governments cannot interfere unless there is overwhelming and unavoidable evidence of danger to law and order. Sir, restrictions must meet the proportionality test. The doctrine of proportionality demands that any restriction on a fundamental right must be necessary, minimal, and proportionate to the alleged harm. The blanket ban is an excessive restriction. Sir, in the case of Modern Dental College versus State of Madhya Pradesh 2019, In this case, the court clearly held that applied the test of proportionality to determine the constitutionality of restrictions on fundamental rights. Sir, there one more point which I had mentioned here is Section 6(1) cannot be used arbitrarily. While Section 6(1) gives power to suspend exhibition of a film, it must be used and backed by objective evidence. The rights cited by the state were triggered by external provocation, not directly by the film. Sir, in the case of Bobby Art International versus Om Pal Singh Hoon, All India Report 1996, the Supreme Court held that artistic freedom should not be stripped just because a section of society finds it objectionable. Sir, ban has a chilling effect on artistic freedom. So, censoring a fictional film without direct incitement to violence stifles creativity, silences dissent, and suppresses artistic exploration. Sir, in the case of Sharia Singhal versus Union of India 2015, the court held that advocacy, even if unpopular or provocative, is protected only. Incitement to violation can be penalized. Sir, in page number 11, I had mentioned my prayer. So, in the light of the above arguments, the petitioner humbly prays that the ban imposed by the state of West Bengal on the film of The Perilous Story be declared unconstitutional. Section 6(1) of the West Bengal Cinema Regulation Act 1954 be read in conformity with Article 19(1)(a) with subject to strict scrutiny. The petitioner be allowed to exhibit the film across all states including West Bengal. The state be declared to ensure law and order and protect artistic freedom as guaranteed by the Constitution. Thanks so much.
I am Defense Counsel and presenting written statement on behalf of the respondent. With the permission of respected court, may I proceed, sir? I am appearing on behalf of the Defense Counsel and presenting the written statement on behalf of the respondent. It is in the matter of the ban on the film The Perilous Story, as per Section 6(1) of the West Bengal Cinemas Regulation Act 1954, because it is spreading communal hate and political propaganda, hence disturbing public peace and harmony. Recently, in the year 2022, this production house released a teaser of a film named as The Perilous Story, which spiked criticism and controversy. At the same time, the movie revolved around a real-life story of three boys who have been trafficked outside Zambia for the purpose of beggar and forced labor. Along with that, it has been mentioned in the teaser that almost 22,000 boys have been trafficked within 2017 to 2022. 5 months later, after the teaser, the official trailer has been released in the month of February 2023, and which led to the uproar in the country of Zambia, because according to the citizens, there are no official data of the number 22,000. Moreover, the film portrays the Wakabi community is behind the trafficking, which also creating a problem of chaos within the country. The Wakabi community belongs to the minority of the country, and such depiction is portraying the suppression of majority on the minority. Also, Wakabi phobia is getting sketched. The clash of communities and political turbulence is creating communal violence in the country. After getting a clearance from the certification board, the film was released in the theatres in the month of April 2023, which led to the many riots. It raised serious questions on the decisions of the board that they have given clearance to the film without taking uproar and criticism of unreliable and vulnerable nature seriously. It shows the influence of ruling party on board members to let the hatred spread among the communities and divide and rule. It attracted a lot of criticism, such as it is leading to a rise of hatred in between the people belonging to different communities. It might lead to riots, and also there is political motive behind the promotion of such films. Politics nowadays are like that they let the country burn for some votes gaining. Soon after the release, extensive protests were taking place in various corners of the country. The ruling party of the country and the oppositions led the communal violence took a wild turn. A PIL was filed in the Supreme Court of Zambia regarding a factual error that is mentioned in the trailer, which mentioned the number 22,000 boys has been trafficked. The Nishtifor Kroller failed to produce any data in front of the court, although they got clearance from the Apex Court to publish it as a fictional piece of art. The harm that it has already done as spreading differences in the communities can't be cured merely by this action. So the movie should have to be continued on well. The consequences of the release. In the first week of May, the state of West Bengal witnessed a lot of riots and communal violence in the district of Vaigra. And because of this, release of the movie and the riots weren't restricted to the theatres only, but were spread statewide. The government of the state of West Bengal, by the authority enshrined in section 6(1) of the West Bengal Cinemas Regulation Act 1954, in which this section empowers the state government and district magistrates to suspend or prohibit the public exhibition of a film if they believe it is likely to cause a breach of peace. This authority applies to the entire state or specific areas within their jurisdiction. And using its authority, it declared ban on film, the Kerala story, because it is spreading communal hate and political propaganda is kept in it, hence disturbing public peace, public harmony and order as per the reasonable restriction of Article 19(2) of the Constitution of Zambia. Allegations were also made that the film was politically biased because the film was carrying propaganda run by the ruling party of the country of Zambia. I like to present some French case laws in which the ban is justified. In Narendra Kumar vs. State of Bihar, citation number AIR 1960 SC 430, it has been held that the reasonable restrictions can be imposed under Article 19(2) of the Constitution in the interest of public order. The court upheld a law restraining certain freedoms, showing that public interest can override individual rights in certain cases. In Raj Kapoor vs. Lakshman, citation number 1982 SCC 175, it was held that film can be regulated if they violate public morality or decency, which can have cascading effect on public order. Court recognized that cinemas has a deep social impact and thus require careful scrutiny. In Rajat Dholakia vs. Government of India, citation number AIR 1990 BOM 356, the Bombay High Court upheld the denial of certification to a documentary that could provoke communal violence. It shows that state and CBFC have authority to prevent films from being released if they threaten communal harmony. And same is the case here. In Javed Habib vs. State of NCT of Delhi, citation number 2007 Criminal Law Judgment 1240, Delhi High Court. Delhi High Court held that if a film or advertisement has the potential to incite unrest, authorities can act to restrict it, especially when sensitive religious or social issues are involved. In S. Rajnarayan vs. P. Jagiram, citation number 1989 to SCC 574. Although this case mostly protected free speech, but it acknowledged that if expression incites people to violence or public disorder, the state is justified in imposing restrictions. It is quoted that if the anticipated danger is proximate and not remote, the state can take preventive actions. Courts have acknowledged that freedom of expression is not absolute when a film provokes communal disharmony, incites violence, disturbs public tranquility. The state has legal authority to intervene in the interest of public order, especially when supported by statutory provisions like Section 6(1). Thank you, sir.
So my colleague had mentioned that the film is very disturbing and it causes riots all over the state. But sir, my question is that if the film is so much disturbing, then why the Central Board of Film Certification, the statutory body under the Cinematic Graph Act 1952, granted certificate to the film if the film is so much disturbing? Sir, the second point which I want to mention is, sir, there is a judicial clearance. Sir, the Supreme Court of Zambia examined the controversy around the film and permitted its release. Sir, the Apex Court already gives its permission to the release of the film. Then why the state imposed the ban? Sir, it shows that the state override judicial orders. Sir, which I had mentioned in page number 9. Sir, the Apex Court already ruled that the film must be considered fictional and allowed its release. The state's action violates the principle of federalism and separation of powers. It means that the state overrides the judicial orders and the orders of the Apex Court. Sir, if and the point is very much similar, then why CBFC gives the certificate if the film is very much disturbing? So main point which I want to highlight is in page number 11. Sir, the remedy lies in ensuring law and order. Sir, the state shall have to give appropriate response to unrest in deploying law enforcement to maintaining law and order. But what they are doing, they are just punishing the speaker or the artist. They are just punishing the director of the film. They are not maintaining law and order in the state. They are just punishing the artist. There is no direct evidence or any evidence which link the film with the rights. There is no direct evidence given by the state or the state council. Thank you.
Regarding the point of board certification, the board certification is a serious point of discussion, because when such film containing such serious consequences and likely to spread communal violence, how can this board certify that film is fit for the people? And it can be assumed that board is under the influence of the ruling party. Regarding the ban, there is various consequences and various things which has been considered by the state government. Regarding the law and order concerns, there is political communal tensions and unrest through which authorities force that the film's content could incite violence, disrupt public order, and create law enforcement challenges. Therefore, state acted under section 6(1) of the West Bengal Cinemas Regulation Act, page number 17, sir, which allows temporary suspension of films likely to cause a breach of peace. And this film is also spreading some misinformation. The film presented manipulated facts and hate speech, particularly regarding the radicalization and conversion and the trafficking of humans. Such misinformation could harm social harmony, especially in the diverse state like West Bengal. There is political and cultural concerns also. This movie has distorted narrative and is part of larger political agenda. Certain political groups using films like this to polarize society and vilify the states such as Kerala and West Bengal. Legal submissions regarding this also has been done. In its affidavit to the Supreme Court, the state defended its decision as a preventive measure. The ban was not about censorship, but about protecting communal peace and preventing social disharmony. In the end, I like to pray to the court that the state of West Bengal respectfully submit that the temporary suspension of the film, The Pirla Story, was a necessary measure taken to prevent potential threats to public order and communal harmony based on credible inputs and public safety concerns. It is humbly prayed that this honorable court may dismiss the petition filed by the petitioner, uphold the state's action as a reasonable and lawful restriction under section 6(1) of the 6(1) and article 19(2) of the constitution, pass any other order deemed just and proper in fact of circumstances of the case. Thank you, sir.
Sir, my colleague imposed serious allegations on the Central Board of Film Certification. My colleague has said that the Central Board of Film Certification is under the influence of the central government. So my question is that suppose we hear our defense counsel that there are some influence of the central government, then why the Supreme Court gave its permission to release of the film? Why my colleague had not given any answer? Why the Supreme Court, if the film is so much disturbing and it is spreading so much riots in the state, then why Supreme Court gave permission to the release of the film? Sir, after the Supreme Court gives the permission, the film was released, and after that the state imposed ban on that film, which shows that the state overrides the judicial orders. And I don't want to argue with same points again and again. Thank you so much.
Regarding the allegation that they are serious allegation, it is a point of investigation, and investigation should have been issued by the court. And regarding the other point that why Supreme Court Apex Court has passed, Supreme Court defined that they can publish their movie, but they have to be in the front. They have to put subtitle that these numbers are just imaginary numbers and not a perfect number or having legal proofs. That's all.